All right, well, another interesting thing about our court system, and not just our court system, but really every court system in the world now. Our system of law matches that described in the Bible, and specifically in Exodus 18. So, a little bit of background. Moses is married, and his father in law, Jethro, his wife's dad, went to visit him, and it says that Moses just came back and was just exhausted. And Jethro said, "Whoa, what's going on? Why are you so tired?" He said, "Oh, I'm just drained. The people of Israel, I'm just overwhelmed. They all have the different problems, and they keep coming to me to fix it all." And Jethro actually told him, "What you are doing is not good. This is not a good, healthy system, and it's kind of crazy, and it's going to kill you. So stop." He said, you don't need to do it all. A lot of the cases here that you're dealing with are pretty straightforward. This is mine. No, it's mine. Well, whose is it? Okay, it's his. It's like Moses doesn't need to be wasting his time dealing with drama like that. So Jethro said, "Look, pick people that are respectable, that are admired in the community, and have shown themselves to be trustworthy, and they can make the decision." So here's what it says in Exodus chapter 18, verses 25 and 26. It says, "He," this is talking about Moses, "chose capable men from all of Israel and made them leaders of the people, officials over thousands, hundreds, fifties, and tens. They served as judges for the people at all times. The difficult cases they brought to Moses, but the simple ones they decided themselves." And that's key, and that's how our system works. So at the lowest level are the district courts. If they can't handle a case, and they always handle the case, they always make a decision, but sometimes people say, "You know what, I don't agree. I don't like their decision. It doesn't seem fair." Well, then you can appeal it. You can challenge that and say, "You know what, I think this lower court made a poor decision." And then the Court of Appeals will hear it. And maybe you don't like the Court of Appeals decision either. Well, then it can be appealed all the way up to the Supreme Court of the entire nation of the United States. So the Bible's version is they had elders of tens and fifties, and then they had elders of hundreds and thousands. And then, if it was a difficult case, as it says here in verse 26, then it would go to Moses. He was kind of like the Supreme Court. Yeah. So, again, I wanted to reiterate what I said in the previous video, that the Court of Appeals and the district courts here, they also serve for life. They also get appointed by the president and confirmed by the Senate. So they have to go through that same process. With the Supreme Court, it's more rigorous. They will grill someone very in excruciating detail and do research to try to find anything that would disqualify them if they don't like them or have a personal agenda. They will try to see to it that a person is not admitted to the Supreme Court, the Supreme Court in particular. But all of the judges go through that scrutiny. All right, some other stuff. So why do we organize our courts this way? Why don't we have multiple Supreme Courts? Then we could hear all the cases. Because right now the Supreme Court is too busy. They can't hear everything. They have to pick and choose, and they reject the vast majority of cases that get presented to them. That say, "Hey, will you hear me out?" And they said, "Nope, we're too busy. This isn't important enough." So why don't we have more Supreme Courts? Well, number one, you have to have one person who's kind of the final decider. So there's going to, I guess you could make an argument that there should be 4 levels, but that could maybe just unnecessarily complicate and lengthen the legal process. So the long and short of it is, the vast majority of cases are really straightforward crimes. So I should, maybe there's a better way to word this, but there need to be more lower level courts than the higher level courts, even like the appeals court versus the Supreme Court, because there are more common, ordinary, everyday, lower level type crimes. And this does not mean that the crime is not serious. And I think this is one of the things that people struggle with the most. The Supreme Court doesn't automatically hear a case because it involves a famous person. Nope. Because most cases are very simple and straightforward. If someone is a serial killer, a mass murderer, if someone plants a bomb and kills 100,000 people, the Supreme Court wouldn't need to hear that because that is a very straightforward, did they do it or not? Did they take part in the crime or not? It's not complicated. So the Supreme Court, they only hear cases that involve something new, something unexplained, some situation that hasn't been addressed yet. So they have addressed over and over and over again. Our whole court system has addressed murder. So it's very, very, very unusual for a murder case to make it to the Supreme Court. I think it's been decades since they have heard a murder case because that happens. There's nothing really to talk about. They don't care. This is kind of another way of viewing it. They don't care about the particular case that they are hearing before them. They care about the precedent, the standard or example that's going to be set by their ruling on the case. All right, so what cases can they hear? Well, first, they have to have jurisdiction. This means that they have authority or the power to hear something. So if they don't have jurisdiction, they aren't allowed to hear a case. How do they get jurisdiction? Well, it has to be a federal law that is broken for a federal court to hear something. Similarly, it has to be a criminal law that they are breaking. It can't be something very petty, like I promised to give you piano lessons and you broke your promise. It's like, well, that's not a federal that's not a federal crime. It's not even a criminal act. Then there's two types of jurisdiction. There's original jurisdiction, meaning that a specific court has to hear it first. And then there's appellate jurisdiction, meaning it has to go to a different court first, and then it can the Supreme Court can have appellate or jurisdiction only if it gets appealed. That's where appellate comes from. Only if it gets appealed to them. So there are some situations where something happens, and it doesn't have to be a crime. I just threw that picture there. Some sort of legal issue, and it goes directly to the Supreme Court. What would that be? Well, if there's a disagreement between another nation and the United States, we don't let states decide that. So that will immediately go not just to the federal court system, but to the Supreme Court, the United States Supreme Court. And I should point out also that every state has a Supreme Court. So there's the Illinois State Supreme Court, there's the Iowa State Supreme Court. I'm talking about the United States Supreme Court. There are plenty of cases, though. Let's say, hypothetically, there is some murder case that has something unique and brand new about it. Well, the Supreme Court still would not have original jurisdiction. They would only have jurisdiction if it goes to the district court and that ruling is appealed. It goes to the Court of Appeals. That ruling gets appealed, and the Supreme Court agrees to hear it. Then they would have appellate jurisdiction. So what types of things do they have jurisdiction over? Well, anything involving an interpretation of the Constitution, they have the authority. Maybe not original jurisdiction, but they have in general jurisdiction, or appellate jurisdiction, or original, one of the two. If there's a controversy between a state, maybe it's Montana and Canada are arguing over their border or some river that flows between the two, that would be a controversy between states and nations, so that would go that would go to the Supreme Court. Also, any case involving an ambassador or a council member, a public minister, people that work maybe at the embassy, something like that, where we're dealing with other nations, then again that would be the Supreme Court that gets involved. So let's look at the nearest district court for our area. So this is the district court, the Northern District Court of Illinois, and there's the Western Branch, the Western Division of the court, and the Eastern Division. So you can see the Eastern Division includes Chicago. The Western Division is headquartered at Rockford. So if there is a federal crime that is committed in any of these counties, including Whiteside County where Unity is located, then that would go first to Rockford. And that would be the district court of the Northern District Court of Illinois. If you don't like the verdict, or whoever is involved doesn't like the verdict, they can appeal it. That would then be appealed to this map here, which includes the entire state of Wisconsin, Illinois, and Indiana. That makes up the 7th, if you look at the color map here, the 7th Court of Appeals. And that is located in Chicago, Illinois. So if you lived in Chicago, you would go to Chicago for the district court. You could appeal to Chicago for the Court of Appeals. And then, if you're one of the very, very few, and you appeal, and the Supreme Court agrees to hear it, then you would go to Washington, D.C., where they would hear your case. So there are currently, and this can be increased by Congress, but there are currently 89 district courts in the 50 states. And when you start adding Puerto Rico and Guam and American Samoa and things like that, then there's 94 for the entire nation. There are 22 positions in our district court for the Northern District of Illinois. And there are currently 11 positions in the U.S. Court of Appeals for the 7th Circuit, located in Chicago. So again, let me go through a scenario. I commit a federal crime. It happens in Whiteside County. I don't have to live in Whiteside County. It just happens here. So it gets heard at Rockford. I don't like the decision, so it gets appealed. They accept the appeal, and I go to the U.S. Court of Appeals Circuit 7, located in Chicago. I don't like that decision either, so then I appeal it all the way up to the U.S. Supreme Court, where they most likely turn me down and reject my appeal. There's a rather bizarre, or at least it seems bizarre to me, status that you can earn if you are a federal judge. It's called senior status. And they say, okay, you've been working long enough and you're old enough that you can be paid as if you're doing the full-time work of a judge, even if you're only working part-time. And if I was to go over here, this is the Court of Appeals, the U.S. Court of Appeals, the 7th Circuit. These are the judges. Last time I checked, some of these, it might have changed a little bit. But these were the judges at the time when I checked. Well, it's been a while now. Maybe about 10 years, actually. But this will give you some idea. So these were all of the active judges. Although notice the ones in kind of a maroon color here, they have senior status, meaning that they get paid as if they're doing full-time work, even though they only work as a judge part of the time. And I chose to find the pictures for two of these justices. Richard Allen Posner, he was appointed by Reagan in 1981. So if he is still serving, that would have been about 40 years. He is one of the most respected judges, a big intellectual player. Even though he's not a Supreme Court justice, he's one of the one of the people that people turn to when there's some constitutional question. Is this constitutional? What do you think? And they'll, interview him, or he'll write an article about it. Another respected person who was considered for the Supreme Court along with Posner was Frank Hoover Easterbrook, and he too was appointed by Reagan in 1985. And you can see, going back to Ford, we still had, at least last I checked, a judge that was appointed in 1974 and had senior status for at least 16 years, because I checked this in about 2010. I don't remember if I've updated it since then. You can see Barack Obama had a pick, younger Bush had picks, Clinton had picks, older Bush had picks, Reagan had plenty of picks because he served 8 years, and I guess his people didn't leave. But, and this is kind of interesting, this is the total number of judges. There are a lot of vacancies, and I'm going to take the time to bring that up. So there are 9 total possible people that can be on the Supreme Court, and we currently have 9. There are 179 openings on the Court of Appeals. We're going to see how many are vacant. 677 district courts, and 9 for something called the Court of International Trade. So there, in total, there are 874 judge positions. And here I'm going to bring up the number of vacancies at the moment. I don't know if this is coming up for you, but I'll talk about it. Here you see the Court of Appeals. There's 179 authorized judges. There's 1 vacancy, and no one has been nominated yet. For the district courts, there's 677 judges at the moment, 71 vacancies, and 36 people that President Trump has named, and they're pending. And here it looks like nominees pending for future vacancies. There's 1 that has already been chosen for someone who is going to be leaving. That Court of Trade, there's 2 openings. One of them has been nominated already, and some other courts, and 0 openings on the Supreme Court. Let me go back here, and I'll quickly go through the next section. So how do things work? Well, before a case will even appear before the Supreme Court, you need to convince 4 Supreme Court justices that it's worth their time, that it's not a waste of their time, that it's important enough. And, here's the statistic. Over 96% of everyone who says, please, Supreme Court, hear me out, over 96% get rejected. So less than 4% of all proposed cases actually get heard. Which means that 96% of all applications can't convince 4 justices. That's not even half the court. Can't even convince 4 justices to hear them out. All right, so let's say that you did convince 4 justices. So here's a scenario. What happens if over half of them, 1, 2, 3, 4, 5 justices say, no, that's a waste of our time? If a minority, 4 justices say, let's hear the case, yeah, then they will hear the case. So the minority in this case can overrule the majority. What if... we'll come to that later. Here's a case where they weren't able to do so. So Justice, and again this is Chief Justice, John Roberts, spoke out in vain on Tuesday against a lower court ruling that he says will grant all drunk drivers 1 free swerve before the police will pull them over. And that could potentially end someone's life. Roberts wanted the Supreme Court to review the lower court ruling, but he failed to persuade enough of his colleagues, the other justices, so that he didn't get 4. The court declined to hear an appeal from Virginia officials who had their drunken driving conviction of Joseph A. Moses Harris, Jr. thrown out by their state's Supreme Court. Why? It says police were notified by an anonymous tipster that he was drunk and driving. The arresting officer didn't see him break any traffic laws, though, but pulled him over because of the phone call, tested him. Yep, he was drunk, but the lawyers argued, well, you didn't know that, and you can't go based on just one phone call. You have to wait till you see something that indicates that he might be drunk. And that's where Justice John Roberts was talking about granting drunk drivers one free swerve, because the police would have to wait till that swerve happens. But as I said, as the article points out, there weren't 4 justices that thought that was worthwhile enough. Again, they have to be very picky what they hear because their time is so precious. All right, here's another thing that you should know. What if 3 justices die? What if 3 of them have to recuse themselves and say, I can't rule on this because in some way I'm biased? Well, you can make a decision still with only 6 justices hearing a case. So let's say these 4 said, yes, we want to hear the case, and 3 of them, they're sick, or they're dead, or they're recovering from a surgery, or they've maybe resigned and quit, or they had to step aside for this case because of their own personal bias. Well, you have 6 justices, so you can hear a case. You still need a majority, that's all. So here you can have 4 justices say, yes, our ruling is a yes. 2 justices say no. But notice again, 4 is less than half of the entire Supreme Court. But that's still okay. You have 6 justices, and that's all that you need for ruling. So what happens? The yeses win. Let's look at another scenario. What if 3 justices aren't involved in some way? Again, they could be sick, dead, retire, having surgery, something like that. Here, the noes win because you have 6, that's enough to make a case, and 4 of them, you have a majority that say the no decision. What if there's a tie? So let's look at this scenario. Okay, only 1 has died or retired or is ill or having surgery or something like that. So you have 1 out. There's 8 total justices, so you have enough. You have 6 or more. There's a tie, though. There's 4 no's and there's 4 yeses. What happens? In that case, whatever was decided by the lower court is the winning verdict. So if the lower court said no, then the answer is no. If the lower court said yes, then the answer is yes. And then this is important, after that decision is made, whether it's a no or a yes, or no in this case and yes in this case, the justices then have an opportunity to give their opinion on the case. And even if their side doesn't win, let's take this example up here. You have 6 to hear a case. The 4 no's win it. They have a majority. They write their opinion. One of them chooses to write why they chose to say no in this case. These 2 will write why they chose to say yes. And believe it or not, their opinions can still be important and help shape law and legal precedent. So the explanation, the opinion part is very important. And just one famous example from U.S. history is the Dred Scott decision, where they said, let us tell you what we think about slavery. Dred Scott is a slave. A slave is nothing more than property, and property, it's no different than if he was a shovel, and a shovel can't sue the person who owns the shovel. And so their opinion gave extra weight to their decision, what they came forward after listening to the case. And it really got the Civil War really heated. Final thing to say here before I pause and do another section is, after hearing both sides argued, you may wonder, how do they decide? Do they do this in front of people? Yes, no, raise their hands, silent ballot? No, they do this in private. So after they hear both sides argued, the side that says, here's why we think you should say yes. Well, here's why we think you should say no. Okay, they've heard both sides. Then the justices go alone, just the 9 of them. Behind closed doors, they talk it over. Everyone gets a chance to speak once before anyone gets to repeat. And then they all give a preliminary vote. And they start with the Chief Justice. So that would be John Roberts in this case. If I go here. They would start with John Roberts, who has the asterisk here. He votes first. And then they go by seniority. And they just go around the room. I think this. I think this. And again, it's very rarely just a yes/no type thing. They'll have to say, in this scenario, I believe yes. You know, here this is a sketch because they don't allow cameras in there. Here's a sketch of the Obamacare hearing. So they could say something like, I believe this part of Obamacare is constitutional. I believe this part is unconstitutional. And they'll maybe give a very brief explanation as to the why. They hear everyone do that, and then they start writing up their decisions. And they usually give it to a group. Sometimes, and I should go back here, sometimes these two yeses might say yes for different reasons. And so this person will write their own opinion, this person will write their own opinion, and these people will write their own opinion. And maybe this person also writes their own opinion because they don't completely agree with the other three. So there can be many opinions, actually, for cases, especially the really tough ones. Now, this is something that I looked into that I haven't found addressed in the Constitution. This is one of those unanswered questions. What if the Supreme Court has original jurisdiction? And again, going back to jurisdiction, that means that the Supreme Court would be the only case to hear it. Okay, well, what if someone's dead and you only have 8 justices and 4 of them vote one way, 4 of them vote the other way? What do you do then? It says the lower court's verdict wins, but there is no lower court. There's only the Supreme Court. And the best I've been able to find anywhere is that they would just have to keep hearing it out, argue, and try to make a decision. And sometimes maybe no decision is workable. But probably pretty rarely is that something that is acceptable. So we'll pause there now.